Hi, my name is Keith Tokerud. I am one of the lawyers at Scott Tokerud and McCarty. We prepare quite a few trusts in our office, and when we do that, we start using terms that clients aren't familiar with. So I thought today I'd talk a little bit about one of the terms that we use most often, and that's the term fiduciary. What's a fiduciary? A trustee is a fiduciary, but what does that mean? So fiduciary under the law is someone to whom power or property is entrusted for the benefit of a third person. So a trustee, for instance, is empowered by the trust maker to deal with some property for the benefit of the beneficiaries. Maybe it's the trust maker's kids or their grandkids or their disabled child or something. So a fiduciary is someone who voluntarily undertakes a duty to help someone. And it's a situation where the person who's being helped and the people involved justifiably rely on that person. So it's often a situation that involves money, not always. Sometimes it involves a person. So for instance, a guardian under the law is a fiduciary. The guardian is in charge of we'll say a child or a disabled person, helping them with their day-to-day life. May or may not involve money. That might be delegated to another fiduciary called a conservator. So a fiduciary is required under the law to always put the interests of the protected person before their own. They're not allowed to take any profit from a transaction unless it's been agreed to ahead of time. If there ever is a conflict of interest that arises, the fiduciary cannot take advantage of the situation for their own benefit in derogation of the rights of the beneficiary. So for instance, a business opportunity arises. A corporation director is a fiduciary. So a director hears about a business opportunity that involves the same business that his corporation is in, and he takes the chance to go and invest in that, take that business opportunity for himself. That's a conflict of interest. The law does not allow him to do that. He's a fiduciary to that corporation. He needs to give that opportunity to the corporation. So some of the types of fiduciaries besides a trustee and a guardian, a lawyer, an attorney is a fiduciary. We're always required to put our client's interests before our own. When we have a probate or a trust administration, the trustee or the personal representative or the executor is a fiduciary as to the beneficiaries of that will or of that trust. When someone is trying to get other people to buy into a stock deal, that promoter is a fiduciary as to the people that he's trying to entice into the deal. Insurance companies and insurance agents can be fiduciaries as to the policyholders. If you think a trust has a lot of provisions, look at an insurance contract. The law recognizes the complexity of that relationship, the one-sidedness of the relationship, and holds that the insurance company is a fiduciary. They're required to put the interests of their insureds ahead of themselves. So when we have a fiduciary relationship, we have an undertaking by someone to do something for the benefit of a third party, voluntarily. You're not forced unknowingly into a fiduciary relationship. You assume it voluntarily. And when you do, the law says, this relationship could be one where you would take advantage. So we're going to construct all of the rules to require you to always put the interest of the beneficiary first. So that's a fiduciary. A trustee is a fiduciary. Someone under a power of attorney is a fiduciary. I am a fiduciary. I hope this has been helpful to you understanding what the term fiduciary means.